Today, we're diving into the public court filings for a really compelling case, Jeff Patterson versus the United States Postal Service. At its core, this is a story about a formal promise, a pretty serious injury, and a safety net that was supposed to protect a worker, but, well, seems to have just vanished into thin air. Right at the very heart of this case, you've got these two pieces of evidence that tell completely opposite stories. It's wild. On one side, you have a supervisor's text message from 2023, plain as day, saying he just spoke to his manager about an employee's medical restrictions. But then, on the other side, you have that same manager giving a sworn legal statement a year later, denying she knew anything about them at all. So, you gotta ask yourself, how can both of these statements possibly be true? They can't. One of them has to be wrong. To really get to the bottom of this, we need to rewind and go back to the very beginning. You see, the foundation of this whole conflict isn't just a verbal agreement or a handshake. It's a formal promise made on paper that was supposed to be completely unbreakable. So let's walk through the timeline, because it really maps out all the critical moments. It all starts back in November 2021 with a work-related spinal injury. Then, by February 2022, he gets a diagnosis of degenerative disc disease and a formal modified duty agreement gets signed. But fast forward to January 2023, that's when the lawsuit alleges the violations started, and it all snowballed, leading to his termination in 2024. So, what exactly is this document we're talking about? It's called a PS Form 2499, and it's a formal, legally binding contract. I mean, this isn't a suggestion, it's an official agreement that spells out, in no uncertain terms, what an employee with a medical condition can and cannot do. For Jeff Patterson, this was supposed to be his guarantee. You know, his safety net to protect his health while on the job. And check out this single sentence taken directly from the signed agreement. It says, the assignment can only, and that word is key, can only be changed with a revised written assignment. This little clause was meant to be like the steel cable holding that safety net in place. The whole point was to make it impossible to change with just a simple verbal command. And for almost a full year, it seems the agreement held, but January 14th, 2023, that was the breaking point. That's the day the lawsuit claims that formal promise was just completely shattered. It all kicks off right here. According to the case file, Jeff Patterson sends a text to his supervisor. He's being proactive, doing exactly what he's supposed to do. He's just communicating, hey, I've reached my 9-hour medical limit for the day, just like it says in his contract. Now, the response he got back wasn't a question or a request. The supervisor's reply, according to the lawsuit, was a direct order, a mandate to just keep working because they were short-staffed. This was a direct instruction to violate the medical restrictions in the signed agreement. So what happened next? Well, we don't have to guess. We can just look at the USPS's own official timekeeping data. It shows that on that day, an employee with a formal 9-hour medical restriction ended up working for 12.75 hours. I mean, he was in an impossible spot, right? Obey the direct order and risk his health, or follow his doctor's advice and risk his job. Now, according to the lawsuit, this wasn't just some one-time incident. The plaintiff alleges it was the start of something he calls a manufactured non-compliance trap. Basically, a strategy designed to create a reason to fire him. And the logic of this alleged trap is just this vicious circle. Let's walk through it. First, management orders work that violates the medical agreement. Step 2, that overwork makes the back injury worse. Step 3, the increased pain leads to medically necessary absences. And here's the really crucial part. Those very absences are then used as the official reason for discipline, which just keeps escalating until, finally, he's fired. And this brings us right back to that core conflict. Because remember, in that text exchange, the supervisor allegedly justified the order by saying, I just spoke to the manager about it. The very same manager who, a year later, would swear under oath that she had no awareness of his medical restrictions. Both of these things simply cannot be true. It just doesn't add up. And get this, it wasn't just the manager. When the supervisor from that text exchange was asked under oath if he was aware of any medical restrictions, his sworn answer was a single word, no. A direct contradiction of his own text message. But this fight is about so much more than just legal arguments and paperwork. It's about profound personal costs, and it raises some really big questions that go way beyond this one courtroom. In his own words, this battle has become deeply, deeply personal.
See, while all of this was going on, he was also the primary caregiver for his critically ill wife, Tony. He's been quoted saying, "Continuing this fight is both a matter of survival and a way of honoring her memory." So for him, this is all intertwined with his own survival and his grief.
And here's the kicker. He's fighting this battle almost entirely by himself. He is proceeding pro se. That's a legal term for representing yourself in court without an attorney. So it's him, by himself, suing the Department of Justice in federal court. I mean, it is a true David versus Goliath fight. And the reality of that fight is brutal. Since he was terminated, he's lost his income and his health insurance. And on top of just trying to live, you've got court fees, printing costs, legal research access, all while trying to cover basic necessities like medication. The financial strain is just immense. So this entire chain of events, from the injury all the way to the termination, has now moved out of the workplace and into a federal courtroom. And this is where the case stands right now. It's active and pending in U.S. District Court. Now, it's absolutely crucial to note that the Postal Service denies all the allegations and denies any liability. No findings have been made by the court. Both sides are exchanging evidence, and a trial is currently on the books for October 2026. All of this leaves us with a final critical question. When a signed contract and a data trail tell one story, but sworn statements tell a completely different one, what is a workplace promise really worth? And maybe more importantly, what does that mean for the rights of every single employee who relies on one?